Welcome to the Ultimate Property Management Virtual Masterclass brought to you by Real Estate Investor. This is day 2 of our 2-day virtual masterclass, which is officially sponsored by WeConnectU, developers of intelligent property management software to enable you to scale and deliver more value to your clients. For those of you that don't know me, my name is Neil Peterson. I'm the founder and editor-in-chief of Real Estate Investor. And we've been serving the South African residential and commercial real estate industry for almost 14 years now through our digital magazine, live events, online content, videos, podcasts, and webinars with insights, education, expert tips, and investment opportunities for newbie and savvy investors, home buyers, landlords, developers, and for all of you, the property professionals and practitioners in the industry. And I'm really excited and honored to be your host and moderator for this virtual masterclass today. Management, the future of rental portfolio management, and we're talking specifically for rental agents, property managers, and investors. So property management today is probably the most critically important factor in owning and investing in property today. I mean, lockdown has been a big catalyst in shifting property managers to becoming more tech-enabled in operating their businesses, and it is critical for more efficiency and, most importantly, to deliver more value for your clients. Many detractors say that property managers they lack innovation, and if they don't embrace PropTech, they will certainly die. And there has been an influx of several tech companies disrupting the property management space recently, and it promises to transform the old traditional real estate industry as we know it. And today we will introduce you to some of those experts, innovators, and thought leaders of property management solutions and PropTech that you need to consider to automate and grow your business. So Real Estate Investor and WeConnectU have a common goal over the next 2 days, which is to fast-track PropTech usage in the property management space area. So, and we've got to thank WeConnectU for sponsoring today's event. Thank you to you guys. And we have a stellar lineup of real estate business experts. Next presenter is a practicing attorney, notary, and conveyancer operating from the Helderberg branch in Somerset West of STBB Attorneys. He's been practicing for 25 years as a director, a member of the executive committee of STBB, also the branch head of the consolidated Helderberg office, previously the Somerset Mall and Stellenbosch offices, where she practices as a conveyancer and notary with specific focus on sectional titles, developments, bonds, and transfers. She's also a practicing family law attorney with special interest in constitutional law with regards to children. Her name is Annetjie Coetsee, and it is Annetjie Coetsee with an S. She's a director of STBB Attorneys, and her topic for today is getting your POPI Act together, which everybody wants to know about. Yesterday was an extremely popular topic, and I'm sure that today it's going to be. So please welcome Annetjie Coetsee.
Good morning, and thank you, Neil, for introducing me. Thank you also for the participants. It's lovely to be here today. I think when people talk about acts and getting your act together, they often have a negative perception. But I would like to say to you that I really think we've got good news. We all know about POPI legislation for a long time, and since 2013, it's been around. There's some changes. It became effective in 2014, and in 2020, the last part came effective, and we had 12 months to prepare ourselves for the POPI Act. So I think it's just from a practical point of view, every day we get an SMS from a life insurance company, funeral company, or somebody that's phoning you from a true caller number, a spam number, and we all had enough of that. So it's good news. We need to have measures, and we need to protect our privacy, which is part of our constitutional rights in terms of Section 14. So what I would like to do today is take you to a place called POPI. It is in Peru. You arrive there and you don't know where you are. You don't know where to go. And what I would like to do is to take you up this mountain and to get a little bit of perspective of what are the important things that you have to focus on. It is quite important for your businesses, your business owners, and you need to get your act together. We only have 3 months left. By the 1st of July of this year, you need to be compliant. And if you're a business, you must be compliant. So it's important, if we look at the definition of the protection of personal information definition, we see that we have to have certain minimum requirements for the processing of personal information. And it's there. Advocate Pansy Tlakulu is very much alive and kicking. You can go onto the website, you will see information there, you will even find case law. So that is important for all of us as business owners to implement into our practices, and we have little time. I don't know why we always wait so late to do what we have to do. In my office here in Helderberg, I often say to my staff that we don't have the P word in the office. They're not allowed to use the word, and that is the word problem. But I'm going to address some P words with you today. That's not problems. The first one is the Personal Information Life Guide. And then we're going to look at processing the conditions. How do you achieve protection? We're going to look at the penalties, which I always like to look at because it's important to know how you will be penalized if you do not comply with the legislation. And then we're going to look at the best practice for POPI compliance. So I trust that this session will help you to focus on the most important things that you have to get ready for your business. So if we look at the POPI Act, it deals with the full life cycle of personal information, from cradle to grave. In other words, to use one example, the gathering and collecting of information. The first time when you conclude a contract with a client, you take a mandate from a client and you ask him or her for certain details. You ask for the ID and the cell number, you ask for an address. Thereafter, you start processing and you record on your cellular phone, on your laptop, your desktop perhaps at the office, a mandate form in your office. All of this information you collect. It could even be a client coming to your office. They go through the security gate. The security guard would ask your client, please provide me with your driver's license. They take your registration number, all the details before they are allowed to enter the premises. They come to your office and you even have a pricey CCTV camera at the entrance of the agency or your shop that you've just installed for valid security reasons. And you make a visual recording of the client. Whilst you have him in the office, you make a copy of the ID, and as it goes, all of a sudden your printer gives you problems and you get a slightly smudged one, you throw that one in the bin to the printer and you make another copy. The second one is better, and that one you add in your file. So if we look at that first part of the cycle, it's the concept of taking the information and collecting it, using it, storing it, modification or even destruction then later of this information. Often we get this from an email address via a web form, or storing a list of customers' addresses, or sending a person marketing communication. And if I look at the amount of participants this morning, I also would like to know, where did you get all these participants from? So very important for us. Looking at storing, you will keep this detail with you in your office, on the computer system, on your phone, or on your laptop sometimes, or a hard copy. Sometimes we have a cabinet where we keep documents safe and secure, and you just maybe never lock up. Or you have spare keys in any event, and somebody can access the cabinet. Thereafter, you will disseminate with the information. You'll forward the ID of your client to someone else who is also a role player in your business by way of mail or scanning or WhatsApp, or you can even send it to information at stbb.co.za, and people have information about your personal privacy, important things. So the next step in this life cycle would be destroy this information after you've dealt with the client. Sometimes you will keep the file for a year. In our offices, we keep them for 5 years after we destroy it. And then we send it to a company that shreds the documentation. We had a very interesting case the other day in Cape Town where the wind was howling and rain, and the shredder company lost some of the papers, and it was everywhere in the street. And it's possible that people could lose personal information that way. So we need to look at how we destroy the documents that we have that contains personal information. So let's look at the processing conditions. And I promise you, if you are looking at these 8 processing conditions, you will have protection if you follow them stringently. If you collect your documents and process the data, then you will be okay. And this is what I think is most important for you to do. Think of these as legally binding principles that must underpin all processing of personal information within your company. And I'm going to use a very simple example. Pretend that you, on behalf of your business, were requested to find a suitable tenant for a home, and that your client, the landlord, wishes to rent out. Summarized, you need to follow the following conditions to process. Number 1, you'll have accountability. You, as a business owner, or an agent or an agency, must ensure compliance with POPI when you are collecting data from the prospective tenant. Secondly, lawfulness. And as Sean said earlier in his presentation, there's quite a lot of laws that we have to comply with, whether that's FICA, POPI, Eureka. There are just so many of them, but it must be legally justifiable. And it must not be just collected from third parties. You must try and get it from the client. Only from third parties, if you have a very good reason, you will be able to explain it. There are 6 grounds of justification. I'm just going to briefly mention them. I'm not going to go through all of it. Number 1, you need to have the consent, and the individual must give clear consent for a business to process that data subject's personal data for a specific purpose. There must be a contract. So the processing is necessary for the performance or the conclusion of a contract to which the data subject is a party. Then a legal obligation. The processing is necessary as it complies with an obligation imposed by the law. There must also be a legitimate interest of the individual. And then public law. The processing is necessary to perform a public law duty by a public body, like we all do as businesses. And then legitimate interest of the responsible party. So that is you as an agency or a business that collects or holds the personal information. In our example earlier, where you've asked for a tenant, you ask his banking details and his FICA documents, as well as proof of employment perhaps. And these could all be justified under the exceptions. You need to get the consent of your clients to process it. It's very, very important. Number 3, purpose limitation. All personal information must only be collected in connection with a specific purpose, and you can't store it for a longer time than necessary. In the example that I used earlier, where the agent asked for the other details, you can't ask for church affinity or gender or sexual orientation. That would be against the Act, and it would exceed the purpose of what the agent is required to do, and this will not be compliant with the principle. There's also a further restriction on further processing of the information. You can only use it for that specific purpose for which it was collected and under specific conditions. Going back to the example again, if the agent were to keep the email address and the contact numbers of the landlord and the tenant with the intention to market it to other properties to them for sale or for rent in the future, or you've got a development that you want to send out, you need to have that consent and specific request from them to do so. If you don't do that, this condition will be breached. Then number 5, information quality control. You need to have somebody who will check, make sure that all the personal information is complete and accurate. And as I said earlier, it must be ideally obtained from the person himself, where possible. In other words, like in our example, the information obtained must come from the tenant himself. You can't get that from the landlord. And the agent or the person, the business owner, must make an effort to ensure that this is recorded correctly. The 6th condition is openness. Personal information must be processed in a transparent manner. And we all know honesty is the best policy. Please make your client aware that you are going to use this data that's collected for the purposes of the application of the lease. What are you going to do with this information? And it could be achieved very easily by a note in the application form. So you need to look at your forms. This might be, you have to change that to collect the information and specifically mention the purpose why you're asking this information, and then also mention that you will store it securely in terms of the agency's privacy policy. Number 7, security safeguards. Personal information must be processed securely, and the responsible party must provide notification of any data breaches. It is very important, if you had a data breach, somebody's stolen your phone, your laptop, you have to communicate this to your client. You can't just leave it, because you must make it known to other parties, because it could be very dangerous. We see fraudulent transactions. We see how people hack email systems, and big amounts of money could be applicable in a specific instance. The last one, number 8, is data subject participation. People must be allowed to access their personal information, and they can also request that it must be corrected or deleted if it's inaccurate. There's also a form attached to the regulations that clients can use, and whereby they can actually request you to remove information. So the agency, again, as in our example, must have a system or a process in place to answer a person's inquiry regarding what information of him or her the agency is holding. So you must ask for that, and you must be able to rectify the information if the information is incorrect. So, what happens if I don't comply? You know, it's very important to say that laws are there to protect you. A law can never harm you. If you look at the National Road Traffic Act, it's there to protect us. People, you can't drive too fast. There are certain rules and regulations that we need to abide with. And again, this is what POPI is for. It is there to protect privacy. In terms of our constitutional rights, we get so many calls and so many people that infringe on our privacy. Recently, we had the whole debate on WhatsApp, and should we now switch to Telegram because people can have access to my personal information, and rightly so. Laws are really from the beginning of existence of time. We had the 10 Commandments, and from a biblical perspective, also there to protect us, and the same here. So what happens if you don't comply? The penalties for non-compliance are quite extreme. Imprisonment, yes, you heard me correctly, imprisonment, or a fine of 1 to 10 million rand. It could also involve compensation to the customer if any damage was caused to the client. The other thing, and that is, I think, the most important for me, is that a trust relationship is broken. That is a key factor in all our business relationships. You don't want somebody to leak information about your personal information. Your reputation is at risk. So I think that is far more important for you to protect it. And we had a very a recent incident in one of the STBB offices where one of my partners in Johannesburg tried to assist one of the clients by way of using an agent. You know, when we register deeds in the deeds office, that information must go from the deeds office, the data in the deeds office must go to the municipality, and then the account details must be changed. But we have COVID and deeds office closures, and that communication sometimes could take quite a while. So she appointed an agent to assist us to get the information rectified at the municipality, and the client did not consent to this. And she was in big trouble about that. And I say that because we need to be transparent and we need to be open and ask our clients whether we are allowed to use this information. So going further, I just want to say it is vitally important, practically speaking, to implement the correct policies in your business. So in short, I'm going to discuss the best practices for POPI compliance, what your business needs to consider when wanting to comply with the new POPI Act. Remember, this is very a broad overview. We're standing on the mountain, we're looking down, and we're looking at the key compliance aspects. It will still be in your best interest to speak to an attorney to assist you with complying. It really is important. You have to look at all these components and then you will be okay. I'm just going to highlight this to you. First and foremost, you need to look at all your agreements. It must be amended to ensure that your clients have the opportunity to opt in and to do any marketing or sharing of information. When I have a client, we do a transfer, I give them a consent form and I ask them, would you like me to send you information of anything from STBB from a marketing perspective, or would you like to be added to our database when we roll out the new development? It is important to have these clauses in your agreements with your clients as business owners if you're going to use that information. You're also going to have to ensure that all your agreements with third-party service providers are also geared towards POPI compliance and that you are protecting all information that you have access to. I had a request this week for the first time. I was quite surprised because the client asked us, can you please send us your policy? What's your policy? And that is something that you as business owners will have to do from now on. You'll need your own internal policies. It's compulsory to have a privacy policy for external purposes. A client must have access to this privacy policy to see what are you doing, how are you doing it, and they must have agreed to the terms thereof. A suggestion would be to add this to your website. Then something else, and we can assist you if you would like us to, that you need to train your staff. They must be aware of the contents of this privacy policy. You must have your internal privacy policy, which will include exactly how is your business going to be processing the information, what are you going to do with it in this personal information life cycle that we've gone through in your business, with the processing conditions of accountability, lawfulness, and security safeguards. And each business is different, so it should be drafted in accordance with your unique business. It's not something that we can use for all businesses. Each business is unique, like you are. Then you must have an external policy, and I'm just going to quickly touch on this, what it should include, your commitments to your customers or your stakeholders, people working with you in the industry. You also need to show how customer information is collected and used, how it is shared, how your customer can track account activity, how the customer information is provided to third parties. You need to explain that. Data protection and security, and obviously your opt-out and opt-in choices that customers can make with respect to the information. Customer privacy rights is also important, and questions about privacy. When you have login information, make sure that that is confidential, that nobody else can get access to that. Your employees must also know the privacy practices. Data retention, this element can be grouped into two general categories: communications and marketing, and then also the legal side, the compliance, and your IT. The next one that we look at is direct marketing. This has changed significantly, and you are no longer allowed to market directly to a potential customer without the express consent to such direct marketing. Section 69(2) of the Act requires of you to obtain written consent from the client. In this regard, you can look at Form 4, which is also attached to the regulations. There's quite a lot of forms if you want to lay a complaint. You can go there. The forms are available on the website also on the information regulator. You will only have one opportunity, guys, and this is the most important thing if you do direct marketing, and we all do that. The trick is that you only have one bite at the cherry, only one opportunity to ask and obtain the consent of the client. If the client says no, it's no. You can't communicate later. Make sure, especially when you're dealing with different branches, that the client, if the client says to you, I don't want to receive any information from you, you're not allowed to use this private information in Johannesburg, and you've got a Cape Town branch, that they are aware of that. You must have these internal compliance measurements and regulations. Very, very important then, maybe that you can use your existing clients to market to, and they should be allowed to unsubscribe. Give them the option to opt out of marketing and communication. It's one of the worst things if you get marketing information, SMSs, WhatsApps all the time. It really is bad. The other thing that you must look at is your IT security. It's a very important aspect of your business when you consider what's happening out with the technical, logical era that we are living in. People are able to access your information. We have to look at this and we have to protect this. You need to do training with your IT people. They must look at your systems, and your IT staff should be part of this whole process to make sure that your business is compliant. You need to train your staff members, all of them in your organization. Staff should be made aware of open Wi-Fi dangers. That's also very important, especially when you're dealing with the personal information like banking information, your bank statement, or anything like that. Then you need to look at your database that you've collected over the years. We were all very clever over the past years, and we've collected data whereby we can use this information and invite you to a webinar like this morning's. And now you have new staff joining you. They come from another company. They bring their data and their information. You need to have a policy about this and make sure that you don't overstep. Also, where you have a central database, as I said earlier, with various branches, have a look at that. Then the last thing, which is the best practice, and I said this is the most important things that you need to look at holistically, is an information officer. The head of an organization is automatically the information officer. So if you as a CEO don't want that role, I think it's imperative that you delegate this duty to a very responsible party, somebody who knows and understands what is required in order to comply with POPI. It's not a policing role, but it's rather an evolving role in order to comply, because it continuously deals with information. We continuously deal with processing of information in a specific organization. We deal with complaints, people that are not happy that you've shared the information. We deal with breaches, and that's very important, as I said, to ensure compliance and practice being implemented in your organization. Make sure that you appoint someone who fits the description of a person who takes responsibility, because it's very important. As I said, if you look at the penalties, that person must know your business. They must understand the inside of your business. I think they must be a little bit tech savvy and continuously improve your internal policies as time goes by. Keep your staff aware of the compliance procedures. It is important. So, lastly, what's important? What can I say to you? I think the most important thing is that we all have to change our attitude about the protection of personal information. It's there to safeguard us, all our information. We have to rethink how we process information, and you need to be informed about internal policies and procedures. Use this as a marketing tool. We have 3 months left. 1st of July, you need to be compliant. You need to have your officer. You need to make sure that you've got your policy in order. And we are there to assist you if you need any information, or if you need assistance with your policy. Please contact us anytime. So I would like to say from my side, thank you very much. Siyabonga, Kayaliboga, Inkosi, Baie dankie. We really enjoyed sharing this with you. And if you have questions, you're welcome to post them.
Yes, great. Annetjie, that was fantastic. I think it's a very topical subject right now. And I also think you scared the living daylights out of a lot of people with imprisonment and that fine of 1 to 10 million. So, but we hear you. We've got until the 1st of July. Thank you very much for your inputs, Annetjie.